Hi, thanks for using My Court Coach. I'm Sarah, and I'll be your instructor today as we discuss community property versus separate property. California is a community property state. What that means is that there's a presumption that arises that all property, real or personal, wherever situated, acquired by the parties during the marriage belongs to both of the parties equally, and it is the court's goal to divide those assets and debts equally. The important things to know about community property is that it includes income. So even though one party may be working, whatever money they deposit into the accounts belongs to both parties equally. It also includes debt. So if there is debt at the end of a marriage, then the courts will also strive to divide that equally between the parties. By contrast, separate property is any property acquired by a married person prior to date of marriage, after date of separation, or by inheritance, bequeath, devise, or descent. All those are fancy words to say by inheritance or gift. How would you prove your separate property characterization? First of all, the burden is on the person who is claiming the property as their separate property to prove it. They could do so by a tracing. So for instance, if funds are deposited into a party's account prior to date of marriage, then that party would be responsible for producing all the bank statements showing that that money remained in the account, and importantly, that it was never commingled with community property funds. So in other words, it shouldn't be mixed in with funds that were earned during the marriage. And sometimes you might need a forensic accountant to do this sort of tracing. So I hope you found this helpful. Good luck.